Okay, it looks like everyone is in. Thank you everyone for joining. This is going to be an exciting one. We have a very good presenter here today with us, Domini Bonas, who's the RVP of Wealth Planning at CI Investments, and she is a lawyer and legal expert. Uh,
Not.
and and today she's going to be talking about executorship and some of the pitfalls that one may face as an executor or in choosing an executor. And as most of you have been on previous calls, we try to keep it somewhat informal. So Domini has a presentation that she will present. But if you have questions as she's presenting, feel free to ask. And we have a Q&A portion at the end as well. And so with that, Domini, I'll let you take over and do your thing.
Okay, awesome. Thank you, Mike. So I'm here to speak today about a very important aspect around your estate plan. So I think personally one of the most important elements in deciding on how to set up your estate. It's choosing your executor and what you should be considering. So I have a slideshow that I'll put up right now. Go.
There we go.
So today we're going to cover at a high level what an executor is, cover what the duties of an executor involve, what you should be looking out for when you're selecting an executor. What are some important qualities of an individual who you select for this role, and then cover off some options when thinking about an executor and an important piece of the decision making around your choice of executor is compensation, and if you're going to be providing them with compensation and what a reasonable amount of compensation may look like. So, the dictionary definition of an executor is it's a person who's appointed by a testator to carry out the directions and requests in the testator's will and to dispose of the property in accordance with the testamentary provisions after his decease. So that's a lot of words pretty much to say that it's the individual that you select to step into your shoes once you've passed away, to carry out your wishes after your passing, your wishes as set out in your will, to take control of your assets, pay off your debts, and deal with any individuals who you want to provide for, ensuring that your assets are well taken care of, and essentially stepping into your shoes once you've passed away. So that's the definition of an executor, and they have legal duties, some obligations that they must meet when acting. So we have to ensure that an executor avoids any conflicts of interest, that there's no self-dealing, that they're acting at all times in the best interests of the beneficiaries of the estate. We have to ensure that the executor is not delegating decision-making tasks. So an executor can hire an individual or a company to assist with the administrative duties associated with the role. But when it comes to decision making, they have to ultimately make the decision. So when it comes to deciding, the example of real estate, when it comes to deciding if a property has to be sold and the value to assign to that property, an executor can get the advice of a real estate agent or other experts with knowledge about the value of the property, but ultimately, when fixing the value of the property, that decision is on the shoulders of the executor and only the executor. They can't delegate that decision making to anybody else. An executor has a duty to invest trust assets in a prudent manner, meaning that if there's an investment that has to be maintained over a period of time, if there are trusts that the executor is responsible for overseeing, they have to ensure that they are making decisions in line with the prudent investor rule. There's also a duty to be even-handed when it comes to the treatment of beneficiaries. Now, this is a long-standing obligation or duty on executors to treat beneficiaries in an even-handed manner. It is, of course, possible in your will to override this obligation or this duty to treat beneficiaries even-handedly. There are instances where it's necessary to favor the interests of one beneficiary over the other. And so we need in language in the will that authorizes the executor to do that. For example, if there is a beneficiary with special needs that needs to have preferential treatment, it may be necessary to prioritize their interests, and we would need a provision in the will that authorizes the executor to override the legal duty on the executor to maintain that even-handedness. There's a duty to also account to beneficiaries. This is an important one. An executor has an obligation to maintain excuse me, an accounting. So the value of the assets at the time that they take on the administration, the value that they sell assets at, the value at which point in time that beneficiaries receive the assets, there has to be a continuous accounting of estate assets and disclosure of this accounting to the beneficiaries. There's a right that the beneficiaries have to this information. So we need to make sure executors are maintaining accounts and providing full disclosure to the beneficiaries. And also they have an obligation to keep beneficiaries reasonably informed. So we want to ensure that the executor is communicating with the beneficiaries, allowing them a sense of timelines, an awareness around what the assets are being sold at, or what the income that's being generated with some of these estate assets. There has to be disclosure and communication of this information to the beneficiaries. I find oftentimes that the breakdown in the executor and beneficiary relationship is related to this breakdown in communication. So when there isn't transparency, when the executor isn't forthcoming with this information and managing the expectations of the beneficiaries, that's when there's going to be real problems that arise, when the executor is not taking the time to let the beneficiaries know when maybe distributions may be made, understanding what the eventual distribution might look like, a value that the beneficiaries might be receiving down the road. I'm not saying providing all that information, but managing expectations and ensuring that there's adequate information shared with the beneficiaries. So those are the legal duties of an executor. And then there's also all the work, the tasks that an executor is responsible for overseeing. So immediately on the passing of the testator, the executor is responsible within the first little while to secure the estate assets, get an inventory of debts, communicate with the beneficiaries, and really understand what they're dealing with in terms of estate assets. And that's the first 7 days. And then in the first 3 months, there are additional responsibilities. And then we might be dealing with institutions at this point. We might be corresponding, the executor might be corresponding with banks, investment advisors to get information about the assets of the deceased. But this is just to show, these slides are just to show the amount of work that falls on the lap of an executor. There's a big responsibility with being an executor. And oftentimes an executor would be hiring or retaining the services of a lawyer to give them guidance as to what they're responsible for doing. A lawyer would also assist with the probate application if that's necessary. It really depends on the situation of the estate. There might not be any assets that require probate. And so if probate is required and a court application is necessary to obtain that probate certificate or that certificate of appointment of estate trustee, then a lawyer would be able to assist with that. And then a lawyer would also give guidance around timing of distributions, withholdings that the executor should be aware of, and other legal obligations that the executor should be aware of. So just at a high level, what is probate? What is that certificate of appointment of estate trustee? Probate is really it's a formal court application and a certificate that's issued by the court after the application has been submitted and reviewed and approved of by the court. And that certificate of appointment of estate trustee or probate certificate, what it does is it validates the will. It just it provides the court seal of approval that the executor is in fact the individual authorized to speak on behalf of the estate. It's the court's approval of the deceased last and final will as the deceased last and final will. But A will in itself is valid once it's executed in accordance with our legislation. Here in Ontario, it's the Succession Law Reform Act. As long as it's in compliance with the legislation, the will is valid, but that certificate of appointment or probate certificate just gives the court's seal of approval for institutions that are corresponding in dealing with the executor, that they have no, the courts have approved this individual as the executor, and that the institution then has that assurance that they're dealing with the correct individual and may take instructions from that individual. So depending on the assets of a deceased individual, so if they have significant investments or bank accounts with significant holdings, the institution holding those assets of the deceased individual may require that assurance of probate to get that the certificate from the courts to know that they're dealing with the correct individual. And in that instance, probate would be required when we're dealing with institutions that want that certainty. But when we're dealing with more informal arrangements or ownership of assets, for example, with individuals who have shares in private corporations, when you're dealing with individuals that are known and there's a level of trust and no concern around the will that's being presented, then for those assets, probate may or may not be required. And so that's where we, at the planning stage, when the individual is drafting the will, we can then plan to segregate assets that absolutely require probate. So where there's investments or bank accounts, those assets could be carved out into a primary will, that's a probated will. And then you might have a secondary will to deal with assets that don't require probate. So that's some of the planning around it. But ultimately, that is what probate is, and that is the probate process. And that's why a lawyer might be needed, depending on the type of estate, to deal with that probate certificate. But going back to our slides, you can see that being an executor is quite onerous. There's a lot of to-dos and responsibilities that fall on an executor. So when you're selecting somebody, you really need to make sure that you are selecting someone who's capable of seeing to all these tasks in a timely and meticulous manner. So when you're choosing an executor, there's the usual suspects. I find with working with clients and trying to help them with deciding on who to select as an executor. For clients who are married, oftentimes it's almost an automatic selection of their spouse. They really think about it. They just think, oh, if I pass away, my spouse would be the person to step in and make decisions on behalf of my estate and be responsible to my other beneficiaries. And the spouse is oftentimes the automatic executor in situations when our client's married, but may not be the right individual depending on your circumstances. So for clients who are married to an individual who might be a spendthrift, might not be a prudent when it comes to investment decision making, if they're not an individual who would, if the spouse is not somebody who would want to take on that responsibility, then it's maybe not an automatic choice, and maybe the spouse isn't the correct person to select as your executor. And so it really isn't, it is something to even think through and to make sure that the person that you're selecting, even if it's your spouse, is the correct person to act as your executor. Siblings are often a second choice if for individuals who aren't married or where there's a spouse who isn't the right fit. Siblings might be somebody to consider. So a brother or sister who is capable and has the capacity and the time to take on the commitments of acting as an executor. But importantly, with siblings, you have to be careful that the sibling that you select has a good relationship with the other beneficiaries, that that they have all the attributes of a good executor. We want to make sure that they're individuals who are able to communicate well and effectively and are able to stay organized and are diligent when it comes to the managing the affairs of the estate. Another often thought of option for executor appointment is the adult children. So we have a lot of clients who would select automatically the spouse as the primary executor, and then if the spouse doesn't survive, then it's automatically the adult children of our clients. That's often the route most of our clients go. But again, it's not necessarily the right fit for every client, depending on where the children reside. We have quite a few clients who have children who live outside of Canada. Any executor that lives outside of Canada, particularly in the US, we want to avoid or at least explore if there are other options. Because when we have an executor that's living outside of Canada and particularly in the US, it can create a lot of tax issues for a Canadian resident estate. If we want to maintain that Canadian residency, we want to make sure that all the decision making for the estate resides in Canada, ideally in the province that the deceased was living. And if we have an executor that lives outside of Canada and in the US, it could be found that the estate is in fact in the US, and then we have a bunch of cross-border tax issues that come up. So we like to avoid that and have the executor reside in Canada and ideally in the province that the deceased individual was living in. So with adult children, again, we have to be considering the dynamics. If you have more than one child, really need to think through how selecting one out of your children may impact the other children, and we want to be careful of hurt feelings and disappointment as well. If you're going to be selecting all of your children to act as your executor, again, thinking about the dynamic. Will they be able to work well together? Would one child be taking the lead and the burden of the administration? And is that fair? Is there a better way to select the appointments so that it's a more fair distribution of the work as well? So although automatically you might think, oh, it has to be my spouse and my children, I would urge you to think it through and really think through the dynamics and how your children will work well, if they will work well together, because this is where, again, you're going to run into conflicts and issues and potential litigation if you're not careful in deciding who's going to be acting as your executor. Friends are also often considered for clients who have children who maybe don't live in Canada, or if they don't have children and it's close friends who are also the beneficiaries. We often see that a friend is a good choice for an executor. But again, being careful that the friend resides somewhere local to you and is not a US person, ideally. And then if you're finding that your estate is very complicated and your loved ones or your friends may just not have the wherewithal to take on the responsibility, if you have a business and the operations of the business are quite complicated, you might think of hiring a professional. If you know that there's going to be some tension between the beneficiaries and the beneficiaries are going to potentially give the executor a hard time with the estate distribution, you might think of involving a third-party individual like a professional, maybe a lawyer, or we also have individuals who have special designations to allow them to act as executors. So a professional advisor might be something to think about if you know that there is the possibility of some conflict down the road, or if there's any if there are any complex estate assets, you might think of hiring a professional advisor for the task. And then there are also professional trust companies that provide corporate executive services. I know, Mike, we spoke about Concentra Trust, and I think there was a presentation done by Concentra Trust. So corporate executors are also a great option, and that's their business, that's their focus, that's their area of specialty. So if you want things done well, and you're concerned about ensuring that everything is taken care of quickly, and if there's any concerns about the beneficiaries, a corporate executor is something to think about. But again, we will get into this, but the compensation piece is something to really think through, because if it's an individual you're selecting as your executor who's not a beneficiary, or if you know that it's going to be quite demanding on the individual to act as your executor, and you want to provide them something a little bit more over and above what they'd be receiving from your estate. Compensation is something to think about with each of these options, particularly with the professional advisor and the professional corporate executor. The costs of hiring those individuals, it's going to be considerably more than selecting a spouse, a sibling, or a child or a friend. Let's see. So attributes of a good executor. So we want to make sure that the individual that you select is trustworthy. This seems quite obvious, but it can be often overlooked. Excuse me, how the situation that you're putting your executor in, especially if it's an individual who has some financial instability, or there's depending on family dynamics, again, if there's a child who's going to be responsible for dealing with the sale of the home, or if there's going to be a child who maybe even buying the home from the estate, we need to make sure that that individual who you're choosing as your executor is trustworthy and at all times acting in the best interests of all the beneficiaries. So there shouldn't be any conflict of interest. There has to also be consideration around availability of your executor. So you might have the most suitable individual in all the other elements, but they might have a busy job, or they might have obligations to their family. Like with the adult children example, you might have children who are well equipped on the educational side of it, and very suitable because they're organized and responsible and everything else, but they might have young children and just not have the bandwidth or the capacity to take on all those tasks that we touched on. And so availability is a very important thing to think about, because if the individual is perfect in every other way, but they don't have the time to communicate effectively with the other beneficiaries, to meet timelines and to be efficient in the work that needs to be done, they're not the right choice. And so it's important, if you're selecting an individual, to not only select that individual based on what their circumstances are now, but thinking through down the road what their life circumstances may be, and ensuring that they're alternates, so that if their situation changes and they're finding themselves in a position where they just can't take on all the responsibility, you're giving them an out and allowing them to renounce and allowing somebody else to step up and take on those responsibilities. But thinking that through beyond just what you're putting in place right now, thinking through what their life might look like at the time that they're administering, and giving them some flexibility if they're not able to take on the responsibility of acting as an executor. Being organized and being able to make decisions. This is very important when selecting an executor. You need to make sure that they have these attributes. Being organized alone is not enough. They have to be decisive. If you have an individual who just cannot come to a decision and they're looking for third and fourth opinions before they're able to make a decision, that may not be the right person. You need to move things along. Beneficiaries are going to expect that of your executor, and they're going to expect somebody who's not only decisive, but able to take in a lot of information and process that information to come to the right conclusion that meets the benefit and benefits all the individuals, all the parties. So there has to be a decisive individual that you select. And I see oftentimes when talking around the decision making as to whether a spouse should act as executor, sometimes I have had this clients be quite forthcoming and saying, I don't think my spouse is the right person because they cannot make a decision. I've always had to make the decision on behalf of my spouse. And if I'm not here, they would be just too terrified to make any decision, and things would just come to a halt and nothing would move forward. So the ability to be decisive is key when selecting an executor. And then something else to think about is it has to be a person who's able to deal and to take over and take charge during a very emotional time. So if you're selecting your spouse or your children or another loved one who's going to have a hard time grieving as well as taking on all the responsibilities of being an executor, again, they might not be the right choice. Now, we'll get into this, and there are other services available for somebody who's finding themselves in that situation as an executor who wants to take on the responsibility, but just is emotionally not available to take on the responsibility. You can get the assistance of maybe a professional trust company to do some of the administrative tasks, but it has to be somebody who's going to be able to deal with the grief as well as all of the responsibilities and tasks of an executor. So that's something to keep in mind. Proximity to the testator, we kind of covered the importance of ensuring that that the executor is not a U.S. resident. And if the individual is a Canadian resident, ideally living in the province, that's great. But even more so, you want someone who is not going to be inconvenienced with all the responsibilities and the tasks. So I have a client who has a great uncle who passed away, was not in close, they were not close at all, but she just kind of found out that her great uncle passed away, and there's an estate now that she is responsible for because nobody else is coming forward to take on the responsibility. But her great uncle lived 3 hours away from where she lives. So now every weekend, she's spending every weekend going up to his home, having to take care of all of his odds and ends, and it's really quite inconvenient. So proximity, ideally, if you can get someone who is nearby and it's not going to be, overly onerous or inconvenient for them to deal with the day-to-day tasks, especially at the outset of administering an estate. It's going to require a lot more of a time commitment. If you can select someone who lives nearby, that would be ideal, and make their lives a lot easier as well. So I think I've covered all the other ones, but I think being proactive and efficient, those are all really important as well. These are the key attributes. So when you're deciding who should be your executor, I would suggest thinking through and kind of doing a checklist to see if the person that you selected meets all of these. Ideally, they'll meet all of these good attributes, but if they don't, putting in some contingency planning into your will so that if there's any issue that the person that you select, any hurdles that they meeting, we're able to have a plan B and an exit strategy for them so that another person can step up and ensure that things are moving along for your estate. So another important thing to think about, we touched on this before, is the executor compensation. So in Ontario, the Trustee Act sets out that a trustee or an executor is entitled to fair and reasonable compensation for the work that they do. So there, we have to then turn to the case law, really. The legislation provides that a trustee or an executor is allowed to take fair and reasonable compensation, but then we have to look at the case law to get an idea of what percentages really an executor would be entitled to. So we have these kind of rule of thumb figures. So we have about 2.5% of capital receipts, 2.5% of income receipts. So when we're doing that accounting that I mentioned at the beginning, and the executor is outlining all the estate assets, then all distributions and any income that's generated in the estate, you're going to also provide for the beneficiaries in that accounting. The executor is going to provide this to the beneficiaries, the calculation of their compensation based on each of those line items. So for the money that they take in, they'll get 2.5%, and any money that they distribute, they'll take another 2.5% of that. So you're looking at about 5% overall. That's what it ends up being. Then that's just the rule of thumb. So there is a lot of flexibility with this, depending on 5 factors. And these are 5 factors that we've gathered from the various cases that have been decided around this. So depending on the size of the estate, if it's a very large estate, then you might be able to move up and down from that 5% value. If it's a smaller estate, then it might not be so reasonable to take the full 5% because you're going to deplete the estate. And so up and down, depending on these factors, the care and the responsibility involved. So for that example that I gave you about the client who's now having to travel 2 hours, 3 hours every weekend to take care of her great uncle's estate, it's quite onerous on her. It's very demanding on her. And so she's now having to deal with a leaky roof and securing the home that the uncle lived in, which was completely neglected. So there's a lot of time and energy that she's spending on taking care of this her uncle's estate. And so that might be an argument to increase that percentage from higher than 5%. Because also she's not a beneficiary, and depending if the executor is or isn't a beneficiary, we might be using that as a factor to move that compensation piece up. Then again, the time occupied in performing the duties, the skill and the ability shown. So if we're dealing with a professional executor and they're providing not only the guidance and decision-making on the basic administrative tasks, but they're also providing legal advice, or with an executor who's an accountant providing accounting advice, they might be provided a little bit more compensation than just your everyday executor. And then also the success resulting from the administration. So if there's any estate litigation that's ongoing, if there are any debts that the executor has been able to negotiate down, all those might be indicators of a successful estate administration, and that might also suggest that the executor should be entitled to a little bit more in terms of compensation. So that's just the 5 factors approach, but it really is not a hard and fast rule when it comes to executor compensation. We just use that 5% or that 2.5 in and 2.5 out as a rule of thumb, but it's not binding. It's quite flexible depending on the circumstances. So, and we mentioned this before, for individuals who are appointed as executor and they're finding that it's just too daunting of a task, they're having a hard time with grief, or the proximity is an issue where they're not able to go to the home of the deceased and deal with all of the cleanup and inventorying of estate assets. And in the situation where we have an executor whose life is very busy, they feel that they want to continue to be the executor, but they just don't have the capacity to deal with all the administrative tasks. They may be able to retain the services of a executor agency service. So you might have heard about these trust companies like Concentra Trust, who have executor ease and all these programs available to assist an executor. The executor would remain the person that's liable and responsible for all the decision making, but for the small administrative tasks like inventorying, dealing with the income tax returns, all those things, they can delegate those responsibilities over to a corporate trust company to take on and to assist in that way. So it's a helpful tool. There, it is costly. It's going to eat into the executor compensation if they were permitted a compensation, and then there will be an additional expense for the estate to consider. So that's important to keep in mind that it's a costly service. So if you're selecting an individual and banking on them hiring an executor agency service, that's something to factor into the cost as well. So that's high level what you should be considering when you're selecting an executor. Mike, do we have any questions or anything from the audience?
I have a question actually.
Sure. Yeah.
I'll start it off. It's a two-sided question. Do you have any tips to ensure that you're keeping your estate as organized as possible for your executors? And then on the flip side, if you know that you're the executor for, say, your senior parents, is there anything that you can do to help ensure that their estate is in order for you, so when the time comes, it's a slightly less of a daunting task?
For sure. So if in terms of your own estate, I think it would be important to keep good records of income tax returns that were filed, the value of assets at the time that they were acquired. So for individuals who, for example, have a cottage and there's improvements done on the cottage, you would want to make it easy for your executor who's going to be dealing with your terminal tax return to be able to figure out what the cost base is for those items. So giving them a list of all the improvements, receipts, and any backup that might be needed to bump up the ACB for the cottage property, for example, all that information, make that available for your executor. You don't want them to have to dig through and rifle through all of your personal documents to kind of piece together what the cost base should be, because we want that cost base to be as high as possible. So make it easy for your executor, right? Similarly, when you're providing gifts and loans to beneficiaries during your lifetime, we have this, it's quite common nowadays, especially with parents who are helping children with buying a home. They're providing large amounts during their lifetime to their children who are ultimately going to also be a beneficiary. And during the parent's lifetime, they might be favoring one child and one child may be more in need of that financial assistance, but the parent might want on their death to treat all the children fairly. So when we're providing gifts and loans to individuals who are going to be beneficiaries, we want to keep a good accounting of the money that's being advanced as a loan, if that's what it's intended to be given as, or if it's a gift, we want it documented as a gift so that the executor is not left to figure out, okay, Johnny got 50,000, Sally only got 20,000. Did Johnny get that as a loan? And should his share from mom and dad's estate be reduced? And, should Sally get a little bit more? Or we want transparency and clarity so that the executor, especially if they're quite removed from the day-to-day, they're aware of all these exchanges of money and what the intention around that was. We don't want there to be any questions that could lead to conflict between, in my example, Sally and Johnny. Like, we don't want them fighting, trying to figure out what mom and dad intended. So we're finding it's very common now to help kids with purchasing homes or paying for post-secondary education or whatever it is, where money is being given, but there's no accounting and it's just kind of happening more informally. But when mom and dad have passed away and there's no one there to explain, the reason behind some of the amounts that were advanced, it can lead to a lot of confusion and potentially fighting with the other beneficiaries. So make it easy for your executor. If you're going to be giving gifts to your kids, spell it out why the gift was given. And if it's not a gift and it's a loan, make sure that's known as well. And make sure there's a provision in your will to equalize any amounts that were provided during your lifetime, if that is your intention. So yeah, just making sure I suggest to a lot of our clients to put together a binder where everything, the names of the professionals that were involved in the individual's life, that's available so that they know exactly who to go to, the name of your investment advisor. So include Mike's contact information and know all the resources. Also, if there's any intentions around organ donation, I would suggest spelling that out, ideally in your power of attorney for personal care, because your executor would be responsible for that. Also, with your funeral arrangements, make it clear what you would like on your passing and make sure that information is available for your executor and available immediately at the time that you pass away. Because oftentimes we have executors that they're grieving and they're mourning and they can't even think about the estate administration. So they kind of shut their brain to that and they kind of put it aside. And after the funeral's been organized and arranged and people have, attended memorials, they come across the deceased intentions around what they would have wanted for their funeral. And that's hard and it's you can't undo that. So you want to make sure that the executor has all the information so that when they're doing the planning for your funeral, if that's what they're obligated to do, that they have all those intentions clearly spelled out for them and give the guidance that they need to do the planning how you would want it done. So I think like a binder with all that information would be really helpful. Ownership of your vehicle, all of that you can put into that binder. And get your parents organized in the same way. Have the conversation with your parents about what they would like for their funeral if they haven't made arrangements beforehand. If there's any intention to do organ donation, have that conversation with your parents or the other elderly people in your life where you know you're going to be the one tasked with being the executor. Really understand what they would like so that you're able to see it through how they would have wanted. And then accessing information about prior income tax returns, all that stuff that I mentioned, make sure that that's all organized to make your job down the road easier as well.
Awesome. I have another one for you. You mentioned cottages.
Yeah.
So for someone who has a cottage that they are looking to pass on to their family, or if there's someone who has multiple properties in their estate, is there something aside from, tracking receipts and all of that stuff, is there anything else that they can potentially do to make that transfer a bit more efficient?
Yeah, that's a topic that we spend a lot of time on, Mike. You know that we spend a lot of
Mhm.
time thinking through, especially with vacation properties, like generational vacation properties, really having that family conversation, having a family meeting even to really understand what the beneficiaries' intentions are, their capability to take on ownership, deal with maintenance costs, their ability to share the property, really understanding if the children are going to be fighting about who gets the cottage for the long weekend. All that is thought through and putting in some planning around that. So some clients prefer doing the planning themselves and being able to rule from the grave using a cottage trust. It's not ideal for every client. It's not the right fit for every client, but something to think about if you want to put in the controls now, a cottage trust is maybe something to explore if you know that your children or the beneficiaries are going to be able to come to consensus and to figure out a way to share a property, then maybe insisting that they come up with a co-ownership agreement and building in some structure around co-ownership would be helpful. But really, I think the big thing is to have the conversation while you're capable and able to put in planning as needed. I think that's important to really understand all the key players and their intentions and what's motivating and driving them is key. So family meetings, even if it's not a vacation property, really understanding what everybody is thinking and feeling about, your estate and what's important to them.
Perfect. And in terms of, so not vacation properties, but if someone happens to have a few investment properties, is there something that they can do, like a trust to efficiently pass those on as well? Or are they sort of limited to disposing?
So a trust may be something to think about, and it might not be a trust. It might be setting up some type of a holding company. But there are so many things to think about before implementing that type of planning. It's not like a one size fits all by any means. But a trust would be helpful to provide in some restrictions and parameters around ownership and delegating responsibilities. But with trusts, you also have to think about that, and trusts and corporations, or with any of the planning that I'm talking about, you have to really think through the tax implications, because there are some serious tax consequences for setting up structures like that.
Okay. Um, I have a question here regarding POA, and this individual is asking, in terms of POA with the banks and other institutions, is it a good idea to set up POA prior to when it's actually needed, so it's active in the event that it is needed?
Oh, yeah, for sure. So what we focused in on today was executors and
Mhm.
the individual who's going to take over your affairs once you've passed away. But I strongly feel that a power of attorney for property and personal care is as important, or maybe even more important. That decision process around who you select is even more important than who you're going to select as your executor. We've all heard about the situation where, an individual is perfectly fine and then suffers some type of a medical disaster and is incapable. It might be for a period of time, right? So you might find that you're in a coma, you wake up, and the person that you selected to be your POA for property has completely mishandled your affairs, and now you're in a worse situation. So the person that you select as your POA for property is very important. It has to be someone who's like-minded, responsible, and able to really take on the task and see things through as you would like it to be. So definitely a power of attorney for property is a very important consideration and something that you should really spend time in thinking through before you select an individual. And you can draft your power of attorney for property in such a way that it's effective from the date of signing. So it could be a power of attorney. So the individual that you select may act on your behalf while you're completely capable, just maybe not able to get to the bank, or if you're traveling there, they might be acting on your behalf to see a transaction through. So you could have a power of attorney for property drafted in that way, where it's effective from the date of signing and not only for periods of incapacity. And to the question, I think if you want to set it up in that way, you're able, while you're capable, to see how the individual that you select is taking care of things for you. If they're responsible and they're able to complete tasks as you would want it, so that while you have capacity, you're able to witness this. And then if you find that, the person that you selected isn't the right fit, as long as you have capacity, you can revoke that power of attorney and put a new one in place with a more suitable individual. So yes, you can draft it in that way, being effective from the date of signing. And it's more convenient as well when you draft it in that way, especially when you have a person, excuse me, who's incredibly trustworthy and is going to be honoring all of your wishes and intentions. It's convenient because if you're dealing with any period where you're mentally completely capable, but physically just not able to get to the bank, or to deal with some matter pertaining to your estate, you're able to then rely on that individual to do the traveling to go there on your behalf and take care of things. Even though you're mentally able to make the decisions, you can kind of give the signing authority to somebody else.
And that comes with risks
Yes,
also, right?
absolutely.
Because now you're
Yes,
giving them full discretion and
yes. But again, as long as you have capacity, we can revoke a power of attorney. So it's intervening quickly enough. If you find there's anything that's happening that is, concerning, if there's any abuse of power or anything like that, you need to intervene right away and revoke that power of attorney and revoke that person's ability to act on your behalf, for sure. Yeah.
okay. These two are sort of, I think they're both somewhat asking the same thing, but I'll start with this one. So being joint on your senior parents' investments and properties, is that beneficial? And I'll ask you the next one because it's kind of similar. If the family wants to hold on to the family residence, how should they do it? Keep it in the estate or put it in the siblings' names?
Hmm.
So maybe we'll start with the first one. So let's talk about joining investment accounts and property with the beneficiaries.
Okay. I can understand for ease of transfer, joint ownership sounds like a great idea. When you add someone to title to your investment accounts, or when you add someone to title to your real estate, on your passing, that joint owner through rights of survivorship is able to take on the control and decision making for those assets without the need for probate. Now we went over what probate is. So yes, for ease of transfer, it seems like a great idea to have that. So we don't deal with probate. We're able to have someone from the date of your death or even during any period of incapacity to be able to act on your behalf without having to rely on that power of attorney for property or deal with probate. But when you add an individual as a joint owner, you're also taking on more risk. So when you add a loved one or a family member as a co-owner on your principal residence, for example, you might be risking the ability to use the principal residence exemption to shelter the gain on your principal residence, which from a tax perspective is a disaster. You're also opening up the door for your property claims from that individual's creditors coming forward and trying to assert those claims against your property. So you're opening the door to that risk, that potential liability, and your property being a part of any claim that those creditors could be bringing. If you're the individual you add as joint owner is in a unstable relationship, then again, it could be something that you're introducing into your world that you might not want. It's convenient on your passing or during any period of incapacity to have that joint owner, but there are risks involved. And then I touched on the principal residence exemption and concerns around the principal residence, but there's also the possibility that when you add someone to title to an investment account or real estate, you could be dealing with the triggering of taxes immediately at the time that you're adding them to title two. So you have to be careful and ensure that you're not unnecessarily triggering taxes by adding someone to title. But it's just when you do the cost benefit analysis with the uncertainty around the other individual, the potential for them to be sued by third parties, if they're married, any instability in their relationship, you just don't want to jeopardize, your property and have your property and your asset brought into any dispute that joint owner might be involved in. So I think it's to save the probate inconvenience and the probate fee. So with the probate application, you're paying 1.5% of the value of the asset. I think that it's probably better to manage that risk and deal with that inconvenience and have certainty that your asset is going to be protected and preserved without introducing that risk.
Um, I hope this doesn't put you on the spot, but you
Yeah,
said it may trigger capital gains.
yeah.
Why the may?
So if it's not done correctly, and I have to say quite clearly, I'm not suggesting anybody go and add a joint owner to an investment account or to their home without speaking to an accountant. But um, depending on how you structure ownership, if you're not only adding the individual as a legal owner, but you're also adding them as what we call a beneficial owner, anytime that there's a change in beneficial ownership, and now we're getting into a little bit more legalese, you might be dealing with a disposition for tax purposes. So if you're adding your daughter to your account as a joint owner, and your daughter's now able to spend the money in the account, if the money in the account is hers as well as yours, that's a disposition for tax purposes. And any gain in that investment account on the date up until the date the daughter is added is going to be triggered and taxable. So that's a taxable capital gain. So you have to be careful when you're structuring these joint ownership relationships that you're only transferring legal ownership and not legal and beneficial ownership. So you need to have your lawyer maybe draft an agreement, a trust agreement where it's clear that it's only legal ownership that's being conveyed and not beneficial ownership. But this is where legal advice is key because you might be, not realizing the tax and legal implications and just adding people to title to find that you've triggered a disposition for tax purposes that you weren't aware of.
Perfect. Okay, and then the next one, if the family wants to hold on to the parents' residence, what
Right.
would you recommend? Do they keep it in the estate, or do they put it into all of the siblings' names?
Again, with the principal residence exemption, if the parents were hoping to be able to fully use the principal residence exemption, they might be getting into they might create some issues by adding other individuals. So the children, if they have their own principal residences and now they're joint owners, you might be chipping away at the ability to shelter the gain in that principal residence using that principal residence exemption. And then again, all the things that I described before, introducing the potential for claims from the children's creditors, if there's concerns about an estranged spouse, all of that risk now is the concern of the parents as well.
Okay. And so, sorry, in this case, the parents have already passed. So
Yeah.
I think what has happened is it's currently in the estate, and I guess they're deciding what to do with the property. So is it best to keep it in the estate until they decide what to
So
do?
you should be careful because estates are entitled to what we call a graduated rate for 36 months. So for 36 months, like an individual, an estate is entitled to those marginal tax rates. So that's great for those 36 months. You're going to get the same tax rates as an individual. Beyond 36 months, any estate asset is going to be taxed at the highest marginal tax rate. So we want to be careful to deal with and administer an estate within that 36-month period, because anything longer than that, you're going to be getting into unfavorable tax territory. So I would suggest making that decision well in advance of that 36-month period. And then I would suggest structuring either a trust to hold that residence for the benefit of all the individuals that you're describing as beneficiaries of this trust, or coming up with some type of a co-ownership agreement. But in both of those planning opportunities, you really need to have open dialogue, full communication, and really figure out what each of the beneficiaries are hoping to accomplish through co-ownership, and having that spelt out in an agreement or a trust agreement, depending on what you decide on, so that if there's any issues that come up, there's a dispute resolution mechanism that's included. If there's a sharing of expenses, all that is spelled out, and that will hopefully avoid conflicts amongst the beneficiaries down the road. But I wouldn't suggest keeping without more information anyway. I wouldn't suggest keeping a property in an estate indefinitely, because then we're getting into that highest marginal tax rate, and which is not ideal.
Okay. Um, okay, so here's one I guess that ties to that. What about having to look after property during an extended period, waiting for probate to complete before being able to sell the property? Any comments about parents that are in their 90s and still have a home that they are living in?
So depending on the language in the will, the executor should be able to use other estate assets to maintain any property until it's sold. So you should be able to access, the investments or bank accounts, whatever it is, of the deceased, to be able to kind of fund the maintenance costs. If there aren't funds available other than the real estate, then I would suggest speaking to a lawyer to figure out if money can be loaned to the estate to kind of bridge the gap. But we need to be careful when we're loaning money into an estate because of that graduated rate estate that I described with the marginal tax rates. We don't want to be offside and lose that graduated rate estate status by funding money, giving funds into the estate. So a lawyer should be consulted to figure out how to create some liquidity to maintain the property until it can be sold. But it might be through a loan from a beneficiary or from the executor or some other means. But again, being careful not to lose that graduated rate estate or that GRE status.
Perfect. All right. So thanks for for all of that. I know it's a lot to speak on, and amazing that you could just do that on the fly.
Thanks.
So just for sake of time, I think we'll end it here. Domini, thank you very much. And for everyone who's on the call still, obviously these are conversations that we're continuously having in our meetings. And so we'll continue to do so. And if there's anything that Domini has sort of touched on that maybe once you get off the call, it'll trigger some more questions or something, feel free to funnel them through me and I'll go Domini. I'm kind of speaking on your behalf, but cycle through me and I'll pass it on to Domini and hopefully we can get to the bottom of some of these extra questions. But thanks again. I really appreciate it.
Pleasure. Take care.
Okay, bye bye.
Bye.